Thank you, Mr. Chairman. H.R. 1789, the Promptly Ending Political Prosecutions and Executive Retaliation Act of 2025, would place a check on radical left-wing prosecutors, or really any prosecutor's ability to bring politically motivated criminal cases before judges and juries that may be biased. The last few years have brought about outrageous and unprecedented moves from rogue prosecutors to target one of our nation's top leaders for their own political gain. For the first time in American history, a former president was indicted and faced with criminal charges. After President Trump announced his 2024 presidential campaign, he was indicted not just once, twice, or 3 times, but 4. And 2 of these indictments have come from rogue district attorneys looking to build up their profile, as this committee has explored last Congress, and make a name for themselves on the national stage. In April of 2023, Manhattan D.A. Alvin Bragg announced a 34-count felony indictment against President Trump in the New York State Supreme Court. Instead of prosecuting real crime in New York, as we witnessed in this committee, that they continue to face, D.A. Alvin Bragg made President Trump the focal point of his campaign. And then again in August of 2023, Fulton County D.A. Fani Willis brought about a 41-count indictment against 19 defendants, including President Trump, in the Fulton County Superior Court. Willis even told the news outlets, quote, "We've been working for 2.5 years, we're ready to go," end quote. They could have brought charges years earlier, but decided to do it as soon as President Trump announced his re-election campaign. These politically motivated district attorneys did everything they could to keep Donald Trump out of the White House, and well, we all know that it backfired as the American people gave President Trump a resounding mandate to restore our country's greatness. The American people saw the political persecution led by the Biden-Harris Justice Department's 2-tier justice system that extended to Democrat, local, and state offices. These were bogus indictments, and our rule of law must be protected. The president is the leader of the free world. The level here is not the same. A small-town prosecutor coming in and attacking our commander-in-chief is laughable. We don't do this in America. We never have. And we can't continue to allow America to turn into a country where candidates running for office are prosecuted out of purely political reasons. These prosecutors have weaponized our justice system against its political opponents, and it is Congress's duty to respond, which is why I have introduced this bill and a similar bill from last Congress, which would give both current and former presidents and vice presidents the ability, not a mandate, but the ability to remove their civil or criminal cases against them from a state court to a federal district court. The new bill also expands the eligibility to remove cases also to current and former U.S. officers who are acting within the scope of their official duties or apparent legal authority related to their office. The bill also codifies the immunity recognized by the U.S. Supreme Court for official acts carried out by federal officials. The federal interests implicated by civil actions or criminal prosecutions brought against current or former presidents and vice presidents are pretty overwhelming. A federal court is the appropriate forum to adjudicate cases with such a strong federal nexus. Federal judges, as an example, enjoy life tenure that is largely free from outside interference in their decisions. By contrast, state court judges are readily subjected to political influences, as many of them are often elected or directly appointed or serve shorter terms. In federal court, the jury pool is often drawn from a larger and more diverse district. The rules of jury selection are much more robust than in state court. This helps to ensure that the political biases of one locality do not improperly influence the jury and its decisions. So we must ensure that state courts are not weaponized against current or former presidents, vice presidents, or U.S. officers. This is common sense. We can and should act to provide this option of a fair playing field for legal proceedings for all presidents, vice presidents, U.S. officers, former and current. I urge support, and Mr. Chairman, I yield back.
The gentleman yields back. We now recognize the ranking member for his opening statement.
Mr. Chairman, thank you very much. So the legislation before us today would amend the law so that a president or vice president, or even a former president or vice president, can remove any state civil or criminal prosecution when that case is brought, quote, for or relating to any act while in office. Okay, any act, whether it's public, private, official, unofficial, within the core functions office, within the outer perimeter, or having nothing to do with the office at all, for any act while in office, or where the state court's consideration of the claim or charge may interfere with, hinder, burden, or delay the execution of the duties of the president or vice president. In other words, every conceivable case will be removable. So look what we're talking about. And I hope my Republican friends will listen as well as the Democratic members. We're talking about destroying state criminal jurisdictional authority and power over federal officials. That's really what this bill is about, because it's saying that the president or vice president or former president or VP can never be prosecuted because, of course, it could conceivably hinder the execution of their office. Of course, it's any act, one office. So what we're talking about is, should a president or vice president ever or former ever be able to be charged with a state crime, including assault, rape, murder, fraud, you name it. And they're basically saying no, that has always got to go to the friendlier terrain of a federal court. So let's remind ourselves of what the genesis of all this is. On May 30th of last year, Donald Trump was convicted in New York State Court of 34 felony counts for falsifying business records to hide his hush money payments to women who he'd had an affair with. When he tried to have the case removed to federal court, the judge found that, quote, hush money payments were private, unofficial acts outside the bounds of executive authority and thus not subject to the constitutional removal requirements. It had nothing to do with his office, and the defense was not a federal defense. It was just a conventional alibi defense that you would find in the normal course of things in a state court. Trump also has charges pending against him in Georgia state court after Trump called the Georgia Secretary of State, Brad Raffensperger, famously asking him to just find me 11,780 votes. He was charged with election subversion and racketeering under Georgia law. He withdrew his application to remove his case to federal court after his co-defendant, our former colleague Mark Meadows, was found not to have met the quite low threshold to move his case to federal court, and that the actions outlined in the indictment were not taken as part of Meadows' role as a federal official. In other words, there was no federal defense available, making this a federal question. Last time this bill appeared at a markup, candidate Trump was just starting his campaign. He'd not yet been convicted of those 34 felony counts. His co-defendants had not pled guilty. In 2023, this was simply a bill to get the cases against him out of state court and into the federal system where Trump and his lawyers could try to shop for the judges they wanted. Today's bill looks very different because House Republicans have a new goal. They want to make sure Trump is not held to the same standards as anybody else, in essence, that he's above the law. My colleague's solution to Trump's personal legal problems, which were created by him, is not to make him all but untouchable in the American judicial system. This bill would require a federal court to dismiss any case against the president or vice president or former president or VP that becomes subject to removal, and that's any case in the state court system. The 2025 version of this bill is an autocratic Christmas tree designed to ensure that nobody in Trump's orbit, from Trump and J.D. Vance to Elon Musk and Mark Meadows, is held accountable in state court. That is completely incompatible with the idea that none of us is above the law. It's an assault on states' rights. It's an assault on federalism. It's incompatible with the Constitution, and it does not do justice to the hard-fought principle that nobody in America is above the law. I oppose this bill. I encourage my colleagues to do the same, and I will yield back to you, Mr. Chairman.
I thank the ranking member for his opening statement. The chair now recognizes the gentleman from South Carolina for the purposes of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1789 offered by Mr. Fry of South Carolina.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair now recognizes the gentleman from South Carolina to explain his amendment.
Mr. Chairman, this amendment adds the year to the title of the bill, and it's not intended in any way to alter the substance of the bill. I yield back.
Who seeks recognition?
Strike the last word.
Mr. Chairman,
I have the
I have an amendment at the desk.
Sorry, never mind.
We'll take the strike the last word first, if that's possible. The gentleman from Tennessee is recognized.
Thank you, Mr. Chair. We discussed this bill yesterday in what we are hearing, and it made me think of critical race theory. Critical race theory is about educational, scientific, historical knowledge of the past, which some people think is disturbing because it disturbs them to think that we had slavery in this country, that we had Jim Crow for about 80 years, that we didn't allow blacks to vote forever unless they could count all the peas in a jar. So we got a critical race theory. We didn't like the idea that we killed so many Native American Indians and it was almost a genocide. We want to get rid of that too. This is critical law theory. The Republicans don't want people, and Donald Trump doesn't want people to know that he is a convicted felon. And he wants to find any way in the world to end that. And he wants to say, I didn't do anything wrong. I'm perfect. I'm the greatest guy in the world. Everything happens with me. He got convicted on 34 counts, felonies, by juries that every single juror said guilty, 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 guilty. Donald Trump is guilty, and no matter what you do with this law, he's guilty, and history will record it as such. But what you're trying to do is do his work to have critical law theory and to erase what is a fact in courts. The state court did it in Georgia because, yeah, that's where he called the governor and said, just find me 10,734 votes. I want to change Georgia's election. I want you to cheat in Georgia and get me some votes so I can have the votes to become president. That's a Georgia case. He was interfering with Georgia state election and Georgia state law to get Georgia's electoral votes. Should have been in state court. But no, Donald Trump doesn't want anybody to think he did anything wrong. So he wants to remove it to a federal court and maybe get it into a court with a judge like Eileen Cannon that'll go, yes, Mr. Trump, what you want? That's what they want. They want judges who have no guts, who have no respect for their oath of office, like Eileen Cannon, who embarrassed us with putting off the classified documents case, and who repudiated by the Court of Appeals. They found her actions to be sophomoric at best. These bills are absurd, and for us to be doing them shows us to be supplicants. We take an oath to support the Constitution. Yeah, we can change laws, but this is about critical law theory. Critical law theory. No, Donald Trump did nothing wrong. Donald Trump, in fact, should have been on the Supreme Court because he's smarter than everybody. He knows the law and never would violate it because he knows it better than any of us. Well, BS. I yield back my time.
Will the gentleman yield? Will you yield?
Yes, I yield to Mr. Goldman.
I thank the gentleman. I have a question for my colleague, Mr. Fry. If this is removed, if a state case is removed to federal court, what law applies?
Well, it's the state law, but the process is under federal jurisdiction. So we already do this for ambassadors, for members of Congress. That's how the current law exists as it stands. And so this would extend those the same federal statute to former members, or excuse me, former presidents and vice presidents, obviously.
Right. I mean, I think the law would still apply. The same federal question doctrine still applies. This bill is very clearly designed not to actually correct a problem, but to simply defend Donald Trump and perpetuate the absolute whitewashing that the Republicans have doubled, tripled, quadrupled down on in fealty to Donald Trump, that somehow these were political prosecutions and investigations. And the only evidence of that is that the defendant said it. That's all you have. You have no actual evidence of any politicization or weaponization.
Well, Mr.
If you look,
Sir,
I reclaim my time. If you look at the actual indictments, if you look at the Mar-a-Lago search warrant, there is not an objective judge, prosecutor, or anyone else who understands criminal law who would say there's not enough evidence to charge or to go forward with a search warrant. And all you are doing is trying to create a monarchy for Donald Trump. And that's what you have been doing by yielding all of your power to him for the last 6 weeks.
The gentleman's time has expired. I now recognize the gentleman from South Carolina.
Let me just write the last word.
The gentleman's recognized for 5 minutes.
Thank you. I was going to respond. You said that this was not, Mr. Goldman, this was not politically motivated, but we know that to be the case. In fact, you live in the jurisdiction of Alvin Bragg. You campaigned with Alvin Bragg, who campaigned on going after Donald Trump.
False.
And so to
He didn't.
say-
He never campaigned on going after Donald Trump.
To say
gentleman
that this
from
was
South
not
Carolina's
politically
time.
motivated is not based in reality. This absolutely was. There was coordination with the Biden DOJ. That was both in the Georgia case and the New York case. And so to say that it wasn't and that we're just making it up really kind of goes against the overwhelming evidence to suggest that that's exactly what they were doing to begin with.
Will the gentleman yield for a question?
With that, I yield back to the chair.
Would the gentleman yield for a question?
No.
To me.
To you, Mr. Chairman, of course.
So many questions, so little time. So there were a few things said, and I want to understand so that everyone understands. Currently, a federal judge whose a similar event occurs would be removed to federal court. Is that correct?
Correct.
And if there's ever been a friendly venue, it would be for a federal judge in a federal court. And yet that's been the law for a long time, right?
Correct.
And currently, if it were you or any of the gentlemen on the other side, it could be removed to federal court in many cases.
Correct. And again, it's not a mandate. It's an option that you could remove. And so it is up to the defendant in a civil or criminal case to take that option to remove.
And for those who haven't practiced in federal court, it is not uncommon for federal judges to be overseeing cases that include state causes.
Would the
correct?
gentleman yield?
For sure, yes.
Okay, so there's nothing unusual here. It applies to other federal offices.
Issa, yield.
Just one second. We're extending it only to the president. Let me go through a couple of pieces of history, though, if I could, and ask you questions. President Obama ordered and struck an American citizen on foreign soil and killed him. You remember that?
Yes, Mr. Chairman.
Okay. Terrorist, but he wasn't currently shooting at us or anything like that. He was tried, I guess, in the international court, but we didn't recognize that. Nobody, picked a state where this terrorist was from and tried to prosecute the president. But if they did, without this law, isn't it conceivable that it wouldn't be removed to federal court and you could have a venue that somehow would think they could try the president for his official acts?
That's exactly right.
And the gentleman was referring, I think the ranking member was referring to this idea of dismissal. Is there anything here that dismisses cases that is not consistent with the U.S. Constitution based on, or with the decision of the Supreme Court?
No, I think that goes beyond the bounds of the legislation. This is just a removal mechanism. This isn't a removal and dismissal mechanism.
Okay, now, not having been in district court all over the country, would this case be removed in the jurisdiction in which the state occurs? In other words, if it's in Georgia, would there still be a Georgia federal court hearing it? It wouldn't be removed somehow to Nova Scotia, right?
Correct.
Or Greenland.
Correct, Mr. Well, unless they're the 51st state.
Okay,
we'll
so
see.
just for people that haven't, served on a lot of juries, the pool of federal juries in Georgia is the same pool, whether it's state or federal, correct?
Correct.
So the same individuals would try. The only question is, do the ladies and gentlemen on one side of the aisle don't trust federal judges, but they trust local judges who run for office versus federal judges?
Right. Correct, and have all the potential for political influence based on donations, based on political party and the like.
Okay, so really all you're doing is removing it from the political process to an apolitical process and keeping it in the same geographic area that the case is brought, but removing it to federal court.
Correct, and if you, and as an accomplished lawyer yourself, Mr. Chairman, you know that the jury selection in a federal system, the defendant or the plaintiff know much more about the potential jurors, potential biases, the potential to obviously strike those jurors. You want a fair and impartial jury. You know much more about those jurors in a federal system because the system is much more structured than in a state court. State court, you show up and the jury pool's there and you're oftentimes trying to use your best judgment on who would be a fair juror. And so this, again, gives the former president, the former vice president, the option to remove if they so choose.
And isn't the former vice president still limited to this provision of the interference? In other words, it's not everything. It's based on acts related that could, a former vice president, acts relating to any act while in office. So it's not for life on former presidents, right? It's just for those, for the acts while in office.
Correct.
I thank you. And thank you for yielding.
Thank you, Mr. Chairman.
Who else sees recognition? The ranking, you wanted to hit him?
I think everybody's gone. Are you?
At some point, I would like to move to strike the last word, but I defer to the ranking.
Out of deference to the ranking member of the full committee, I recognize him to strike the last word.
Thank you, Mr. Chairman. I'm just going to follow up on your line of questioning, and then we can go to Mr. Goldman. If the gentleman from South Carolina, if he could come back, if maybe someone could get him to, I would love to pursue the questioning. But here's where I'm going with this while they're getting him, Mr. Chairman. I think you asked exactly the right question. You were saying all this is a removal provision, right? But it's not just a removal provision. It's a removal and dismissal provision. If you look at E on page 5 of the bill, it says, in any action subject to removal under paragraph 5, which is current president or vice president, or 6, which is former, of section 1442A, such case shall be dismissed unless rebutted by clear and convincing evidence establishing that the continued pendency of the state claim or charge would not in any way interfere, hinder, burden, or delay the execution of the duties of the president or vice president. And what I'd like to ask the distinguished gentleman from South Carolina is, can you imagine any case where a president or vice president or formers would lose that in saying this is going to hinder or burden or delay my execution of duties? Who wants to be in a criminal prosecution of any kind? So it's a guaranteed removal and dismissal, because it must be dismissed, it shall be dismissed, unless you can prove it's not going to affect their life in any way.
Would the gentleman yield?
By all means.
I would agree that if you took it out of context, just looking at it here, but the context, I hope we all agree, this is a Supreme Court ruling. We're codifying what the court has already said. And as to a former member, which the president was when charges were brought, the standard would, by definition, be different because he wasn't executing his activities during those 4 years. So the actual dismissal of those cases—
Just reclaiming my time for a second, if that's true, then why should the logic of this apply to him at all? Why should it apply to former officials in any case?
Because the removal would apply, but not the basis to dismiss. That's where the two, as the gentleman probably knows, currently Prime Minister Netanyahu spends 3 days a week in court because they have no such law in Israel at a time in which he's defending his country in a war. We're seeking to make sure that we minimize to the greatest extent possible 50-plus states in which people could bring cases against a current president. And if they bring it against a former president for acts while in office, limited to acts while in office, that it simply be removed to federal court. But I think the Supreme Court decision on dismissal is very different for a former president because they don't meet that standard of hindering his execution of his job.
Okay, well, just to reclaim my time there, if we're talking about a former official, it shouldn't apply at all because they're no longer in office. In the New York case, Trump claimed that it interfered with his presidential duties, nonetheless. But look, I would say this. This shows spectacular disrespect for state courts, state constitutions, state prosecutors, and state law. I mean, I'm really shocked that this is even something we're considering to obliterate state criminal jurisdiction over crimes that exist within their state. And if they're, in some ways manufactured or invented, the state systems are just as capable of vanquishing the fantasy prosecutions as a federal court is, and much better at interpreting and enforcing state law than a federal court would be. And yet—
Gentleman yield?
Yes, I would.
I just wanted to clarify, one of the gentlemen on the other side said that the state judges are elected. Some are, many are appointed, just like federal judges.
That's absolutely right. And so, I mean, this does reflect a basic structural trampling of state court and state legal systems. But I think that the really sneaky provision is this dismissal one, because the overwhelming presumption is that it will be dismissed the moment you get it into federal court, unless you can somehow prove that this will not in any way affect the performance of the duties of the president or vice president. And if they're no longer president or vice president, why are they getting the benefit of this in any way at all? So I do agree with Mr. Goldman that this seems like a very political bill that's just meant to curry favor with, or perhaps soothe the hurt feelings of Donald Trump. He was in those situations because of actions he did. He was the one who said, just find me 11,780 votes. Nobody else made him do that. He made his staff go ahead and call Secretary of State Raffensperger. He was in trouble in New York because of the hush money payments he made, and then he cooked the books in New York. That was his decision. I mean, let's show some civic self-respect here and acknowledge that people are responsible for their own actions. I yield back to you, Mr. Chairman.
Thank the gentleman who else seeks
Move to strike the
recognition.
last word. I move to strike the last word.
The gentleman's recognized for 5 minutes.
Thank you. I want to just pick up on what the ranking member was saying, and a couple of things. First of all, this is not simply codifying a Supreme Court decision, nor is this removal for a federal court to consider a state law claim. And I would point my colleagues to page 4, section B1, for determination of immunity, saying the nature, elements, or any other aspect of the charge or claim made by or under authority of state law. Basically, any state law claim is immune. So it's not interpreting state law just simply in a federal court. If you want to bring a bill that simply clarifies that the rule for judges and members of Congress should be the same for federal official, the president and the vice president, we can discuss that. This is nowhere close to that. This is going even further than the Supreme Court case, because it also addresses civil cases, not just criminal cases. And it also expands the immunity through both dismissal, as the ranking member pointed out, and there are other references to dismissal, but beyond what the Supreme Court says. But even more importantly, it goes so much further than what you're representing. And I would just urge my colleagues not to continually overreach in fealty to Donald Trump. We are happy to discuss thoughtful, reasonable legislation that preserves the rights of a president and a vice president. Why are former presidents and vice presidents even included in this?
Will the gentleman yield?
Yes.
I've got one theory about that, but I would love to be illuminated by someone on the other side of the aisle. But Donald Trump in the New York case was saying that even though he was no longer president, the fact that he had to stand trial interfered with the fact that he was running for office again and was involved in other political activities. So I think they put in former presidents and vice presidents in the event that they wanted to be running for some other office.
Right, and of course, if you expand that to its logical conclusion, every one of us is always running. Always running. So if the argument is, oh, well, you can't charge a elected official or former elected official because they're running for office, Donald Trump very clearly announced his campaign extremely early and previewed the fact that he was doing it so that he could argue that these investigations against him were interfering with this. This was a defense that he created, and then everyone on the other side of the aisle bought into it. But I do want to just answer my colleague from South Carolina on the New York case, which I would point out there was no assertion or allegation that the special counsel's two cases there was any evidence of politicization. He did not mention the Georgia case, so let's just focus on the New York case. Alvin Bragg never campaigned on getting Donald Trump. Never said, I am going to get Donald Trump, I am going to go after Donald Trump. Never. If you have a quote of his, please, I urge you to bring it to me. Never happened. False. Secondly, I don't know what coordination between DOJ and the Manhattan DA's office you are talking about, but I can tell you that as a federal prosecutor for 10 years, I coordinated, I spoke to state prosecutors all the time. We shared evidence all the time. That's how prosecutions work. Sometimes you will charge it in state court, sometimes you will charge it in federal court. But I don't even know what allegations you're talking about. I haven't seen any evidence, any actual support, other than the fact that a former DOJ official joined the prosecution team in the Manhattan District Attorney's Office. I don't understand how that is the DOJ coordinating. He's no longer with the Department of Justice. But you keep making these allegations and you have no support. And it's as if you say it enough times, it just becomes true. But that if you say it enough times, that doesn't mean there's any evidence to support what you're saying, and your allegations are baseless that any of those prosecutions was politicized. And I yield back.
I now recognize myself. I asked that pages, that an excerpt from page 24 of an actual hearing, perhaps you weren't there in New York, but the quote is, let's talk about what's waiting for the new DA, the docket. We know there's a Trump investigation, okay? So here is the reference that came out of it. On March 17, 2021, Bragg indicated that if elected as district attorney, he, quote, will hold Trump accountable. Just a few days later, on March 23, 2021, he again boasted that he had sued the Trump administration over 100 times. In June of 2021, Bragg doubled down, stating that the important work that separate from any that the DA office may be looking at now. In other words, Bragg assumed office with seemingly one goal: to prosecute President Trump.
Will the gentleman yield?
I will in a moment. To say that this wasn't a determination, that he didn't cobble together misdemeanors to create a felony, that he didn't invent something that, quite frankly, had never been done before, that he didn't work around a statute of limitations, is laughable. Having said that, I'm going to, because the gentleman asked me to yield time for a question, I'm going to just ask one question. All we're doing is modifying federal law. Federal law in the state above that, because he kept quoting from 28 USC 1442, it applies to any officer of the courts of the United States or related to the act under the color of the office or performance of the duties. 4, any officer of either House of Congress or related to any act in the discharge of his official duties in the order of the House. Would the gentleman suggest that we strike both of those? Would the gentleman take away his own ability to remove or the judge's ability to remove? Because all we're doing is adding other federal officers and ultimately covering what I think is a branch not covered by this 28 USC 1442. Would the gentleman respond, please?
Yes, and as I mentioned to you, if that were simply all this was doing, I would be happy to discuss this in good faith.
Would the gentleman agree that adding the decision of the Supreme Court, and he did reference the basis for, on page 4 for the basis of immunity, and reading it carefully, I think the gentleman will find that what it actually does is that it states that for purpose of determining the immunity, you will not look at the nature of the charge. And the gentleman did say, what about murder? Well, the question for it would be, was it official act? And I cited President Obama's murder, ordered execution of an American citizen without a trial or a grand jury or any other indictment for actions. The fact is, a state court could have brought charges for that. In this case, it would have been removed. The court would have decided that, in fact, the commander-in-chief made that determination and he had immunity. I'm not disagreeing with the court. What I'm saying here, and Mr. Fry's bill clearly says, is it's to be considered in federal court, and the immunity question is not a question
Would the
that
gentleman
is
yield?
automatically dismissed.
Would
It's
the
a case.
gentleman yield?
Yes, I will, consistent with the Supreme Court ruling, yes.
I'll defer to Mr. Nadler.
Thank you. What President Obama did was an official act. If what President Trump was convicted for was not an official act, if anyone at this table, in this committee room rather, violated the state law by committing murder or by theft or by fraud, he'd be tried in the state court. That would be removable.
I agree with the gentleman that the allegations were not an official act. However, you'll notice in this Mr. Fry's legislation, the removal has to be for an official act to be removed for a former president or vice president.
Not for the president.
No, not for the current president, but for a former president. In other words, the discussion about what President Trump wanted removed during his campaign. Under this, it doesn't change the removal during that period in which he was a former president.
He would have, under this bill, as a former president, the local prosecution would have been removable. Under current law, it is not removable, nor should it be. A violation of state law should be prosecuted at the state level.
I think we just disagree on that. Who else seeks recognition? You've already seen.
I think I've already spoken.
Yep. Mr. Johnson?
Thank you. I yield to the gentleman from New York.
Thank you to the gentleman from Georgia. Mr. Issa, the Constitution applies to state courts as well as federal courts. So the Supreme Court's opinion applies as to official acts in state court just as it would in federal court. So I don't understand what your concern is about the application of the Constitution when that also applies to state court. And I would just say, Mr. Issa, in response to the quotes that you read, saying that I sued Donald Trump previously is not saying that I am going to indict him. And in fact, the investigation that was currently, that was at the time alive, was not the charge that was ultimately brought. In fact, Mr. Bragg refused to bring the criminal case that was under investigation. The line prosecutor who was investigating that case resigned in protest over the fact that Mr. Bragg did not charge President Trump with that investigation. So those quotes that you're talking about in the ongoing investigation that is referenced there was ultimately not brought by Mr. Bragg. So you can have complaints about what the actual charges were, and I think there are reasonable arguments to debate about the discretion, but it certainly was found by a jury to be a conviction. The president will have his appellate rights. He may appeal it, and if your allegations about converting a misdemeanor into a felony and statute of limitations and all that stuff are true, then a court would agree with you. But we already have the proper system to be able to deal with that. And so I think on both scores, you're missing the mark here. Again, if you want to go back just to say presidents and vice presidents should also, 1442 should also apply, let's discuss that. But that's not what this bill does.
Would the gentleman, go ahead.
Okay.